that is the very fabric of what we are as prosecutors. Prosecutors in any country, on a chair, are powerful officials in a criminal justice system. They carry immense discretionary power, whether in determining to prosecute, who to prosecute, for which crimes. And in the circumstances, across the world, there's always a risk that outside actors will try to improperly influence us. We must never succumb to this as prosecutors. The NPA we cannot fulfill our constitutional mandate if our decisions are vulnerable to pressure, direction, influence from external actors, be it from politicians, from the rich, from the powerful, from the private sector, the media, or civil society. As prosecutors, we must vigorously withstand such influence at all times. The decisions we take as prosecutors touch the lives, the liberty, the dignity of ordinary people. Every decision we make to prosecute or not can alter the course of a person's life, be it a person falsely accused or a victim deprived of justice. This is the reason why prosecutorial powers and functions must be exercised diligently, fearlessly, impartially, independent by every single prosecutor in this country and hopefully across the world. We lead efforts to uphold the rule of law. And any perception that there may be, and I repeat, any perception that prosecutions are politically motivated, selectively pursued or not, or improperly abandoned, they erode the legitimacy of and the trust and confidence in the entire system. So given the important work of prosecutors, it is why there are various instruments, which I will deal with in detail, that regulate and guide the functions and behavior of prosecutors. Start with the Constitution, the NPA Act, the NPA prosecution policy, directives, Code of Conduct, the United Nations guidelines on the role of prosecutors, the International Association of Prosecutors, Standards of Professional Responsibility, and their statement of essential duties and the rights of prosecutors. These instruments, together with judicial pronouncements and the common law, emphasize that prosecutorial conduct must adhere to the requisite standards of integrity, of honesty, and we must be fiercely independent, especially from political or public influence, proceeding only, and I repeat, only where the evidence meets the required threshold, and maintaining public confidence through consistent, rational decision-making. This is the context within which the present case sits. I do want to deal with one issue that Advocate Ngugai Toby mentioned yesterday. He said that the case is legally defective and dangerously, I repeat, dangerously seeks to punish a prosecutor for exercising lawful prosecutorial decision. Chairperson, members of the panel, this cannot be further from the truth in this matter. This is about prosecutions that the testimony will reveal were it appears politically motivated, with, I want to say, no evidence. I think carefully about it, because I do think there was no evidence to support one of the charges, or perhaps at the lowest level, if anything, but there was no evidence, in my view, to support one of the charges. And in the other case, it appears to protect someone from being prosecuted when there was strong evidence in the matter. And so this is the context within which this matter is being dealt with, Chairperson. Thank you.
Let me refer you to the affidavit. Go to paragraph 3 thereof. You state there that the facts contained in this affidavit one, based on documents within my possession or under my control, which presuppose that some of the facts that you stated in this affidavit were not within your personal knowledge. If you may explain the context.
That is correct. Chairperson, members of the panel, all of these events that took place were before I took office. I was out of the country for almost 10 years. And so I have no personal knowledge of any of the matters that are referred to or the subject of this particular inquiry.
Are there any facts to which you have personal knowledge?
I'll have to think carefully about that. Most of the facts happened before I was here. I'm not sure if there's anything that I have personal knowledge of in this case.
But let's put it this way. There were encounters. You've had encounters with Advocate Chauke, not so?
Oh, yes, we've been working together for the past 6 years.
So as far as your encounters with him are concerned, would you say you have personal knowledge of what was happening vis-a-vis his work?
From the time I took office, yes.
Yes, okay. Now, you mentioned that you were in The Hague for about 10 years.
That is correct.
What had you been doing there, if you may?
Yes, sure. This year is my 40th year in prosecutions, as a prosecutor. Most of the time has been served in South Africa. I was appointed as the senior legal advisor to the chief prosecutor of the International Criminal Court in The Hague in 2009, and served there until I returned to South Africa to take up the post of National Director on the 1st of February 2019.
By referring to the Hague, are you referring to the International Criminal Court of Justice?
No, not the International Court of the International Criminal Court.
The International Criminal Court.
Yes, not the ICJ.
Okay. Let's go back to your affidavit. You say in paragraph 5.1 on page 2 thereof, in paragraph 5 to be specific, actually, that you have structured your affidavit in a certain pattern, which appears in paragraphs 5.1, 5.2, up to 5.3.
That is correct.
For the moment, you may wish to begin with the mandate, which is where your affidavit begins. The mandate, the powers and functions of the National Prosecuting Authority and its functionaries. Without being seen to be repetitive, you've already briefly touched on that subject, but we deem it important that it has to be emphasized as to exactly what is the mandate of the prosecuting authority and what are the powers, functions of prosecutors, specifically DPPs, in the position of Advocate Chauke.
Yes, thank you, Counsel. I'll start with the mandate. So, as I mentioned previously, Chairperson and members of the panel, prosecutors play an extremely important role in the criminal justice system. In fact, as prosecutors, we are gatekeepers of the criminal justice system, because without the intervention of prosecutors, the matters cannot proceed to trial. Firstly, Section 179 of the Constitution of the Constitution, read with the NPA Act, actually establishes firstly a single prosecuting authority in South Africa. And if we deal briefly with Section 179(5) and Section 22 of the NPA Act, which is in paragraph 12 of my affidavit, The NPA, it determines and delineates, well, these acts, the Constitution and the NPA Act, sets out the powers of a national director. And in the main, these are, firstly, the NDPP must determine prosecution policy, issue policy directives, as contemplated in Section 21 of the NPA Act, which are to be observed in the prosecution process. The NDPP may intervene in any prosecution process when policy directives are not complied with, and a national director may review a decision to prosecute or not prosecute in certain circumstances. Those are broadly the powers of the national director. And there are various sections in the Act that further detail the functioning of the National Prosecuting Authority.
May I interpose that, ma'am, whilst you're still there? I deem it important that the powers, duties and functions of national director should be read into the record as they appear in the NPA Act.
Can you refer me to the section, please?
Section 22. Section 22 deals with the powers, duties, and functions of national director. I may read it into the record.
I'm trying to find my act.
I'll read
I
it
can't
into
see
the
it.
record. Relax, advocate. I'll read it into the record whilst you are finding your copy. With your permission, Madam Chair.
Advocate Mhlamunyane, if I may interpose, shouldn't you look at Section 21C first, rather?
21C.
21C, which deals with the powers to continue criminal proceedings. 21C?
It should be 22C, Madam Chair. I
22C.
believe it 20.
Do you have the act there?
I have the act here. 22(1) powers, duties, and functions of national director. 22(2)C, it's where a director may review a decision to prosecute or not.
Doesn't Section 21C specifically deal with the power to discontinue
21C.
criminal proceedings?
Section 21, Madam Chair, doesn't have a subsection C. What has a subsection C is 22(2).
It is the affidavit that is conceived, yeah. 21. It is 21C.
21C.
Yeah. 20
Sub 1.
bracketed 1
Oh,
C.
20
Yes.
in brackets 1. I was hearing it as 21.
Well, it appears
My
in the
apologies.
affidavit in 8.3.
8.3.
That's where I thought you should start. Just to lay the foundation to the legislative framework. I thought so.
Let me hasten to do that. I agree. Section 20 contains the power, deals with the power to institute and conduct criminal proceedings, and I'll read it into the record. It reads, subsection 1 reads as follows, and I quote, the power as contemplated in section 179 in brackets 2 and all other relevant sections of the Constitution, to paragraph A, institute and conduct criminal proceedings on behalf of the state. B, carry out any necessary functions incidental to instituting and conducting such criminal proceedings. And C, discontinue criminal proceedings vests in the prosecuting authority and shall, for all purposes, be exercised on behalf of the Republic, unquote. May I then proceed to read into the record, Madam Chair, Section 22?
Yes. You see, I raise it because Advocate Batohi deals with that section at 8.3,
I see that.
and it seems very relevant as a founding provision for our purpose.
Indeed, because
Let me just, my sister is ascertaining whether Advocate Batohi has the act. In
I
front
now
of
do,
her.
thank you, Chair.
You do have it right
Yes,
now.
it's not in the bundle. I have my own copy, but
You have
it's
your
fine for now. Thank you.
Yes, thank you. I think you have your style of leading. My sister is suggesting that perhaps you should be the one reading into the record. What do you plan to read into the record? Because she's the one who is speaking to her affidavit. That seems to be correct.
that I should read into
She
the...
must read into the record her provisions, the
Indeed,
provisions that she refers to,
indeed, I was...
because she relies on them. So you can lead her and then refer her to those provisions. Then she can read the contents of those provisions she relies on into the record.
In fact, I was going to do that as advised by my junior here. She has just advised me to rather not get into the fray. Perhaps I was getting into the fray
Yes, Madam, you are
unintentionally.
correct. Yes, thank you.
Unintentionally.
No problem. Commissions of inquiries are not like court proceedings.
Indeed, indeed.
We
Madam
are
Chair.
all learning.
Indeed.
See how we should do our best in executing our tasks. And for that, we are indebted to you, Madam Junior Counsel, and to my sister for reminding me. Do that so that she is speaking to her affidavit.
Thank you, Madam Chair. You have now located your copy of the NPA Act, and I'll request you to proceed and read into the record Section 22, which contains the powers, duties, and functions of the National Director. Please do so.
Thank you, certainly. Perhaps Section 22 deals with the National Director. But if I may, through you, Chair, perhaps we should, given the direction and the guidance from the Chair, perhaps deal with Section 20 and briefly 21 before we go to 22. The Council has read Section 20 into the record. Does the Chair require that I do that again, Chair? Okay, sure. Thank you, Chair. Sure. Thank you, Chair. Chair, so Section 21 was read into the record. I will then deal with Section 23, which we will deal with in more detail later. Subject to the provisions of the Constitution and this Act, any director, referring to a Director of Public Prosecutions, shall, subject to the control and directions of the National Director, exercise the powers referred to in subsection 1 in respect of A, the area of jurisdiction for which he or she is appointed. This is important. And any offences, and B, any offences which have not expressly been excluded let me read it as it is in the Act, any offences which have not been expressly excluded from his or her jurisdiction, either generally or in a specific case by the National Director. Subsection 5 of 21 is also relevant in this regard. Any prosecutor shall be competent to exercise any of the powers referred to in subsection 1 to the extent that he or she has been authorized thereto in writing by the National Director or a person designated by the National Director. The written authorization referred to shall set out the area of jurisdiction, the offences, and the courts. Section 21 deals with the prosecution policy and the issuing of policy directives. The National Director shall, in accordance with Section 1795, A and B, and any other relevant section of the Constitution, A, with the concurrence of the Minister and after consulting with directors, determine prosecution policy, and B, issue policy directives which must be observed in the prosecution process, and shall exercise such powers and perform such functions in respect of the prosecution policy as determined in this Act or any other law. I suppose the next relevant section I suppose to highlight, I'm not sure that there's anything more in section 21 that I need to highlight. It deals with the issuance of directives by the National Director. And then section 22 deals with the powers, duties, and functions of a National Director. Section 22(1), the National Director as the head of the prosecuting authority shall have authority over exercising of all of the powers and the performance of all of the duties and functions conferred or imposed on or assigned to any member of the prosecuting authority by the Constitution, this Act, or any other law. And then I did deal with the next part of it. I did read that into the record, so I will not reread subsection 2 of section 22 into the record. I think those would be the relevant parts of section 22 for the current purposes. Council, I'm not sure if there's any other section you would like me, or subsection of 22 you would like me to read into the record for these purposes.
Yes, Advocate Batohi. If you look at section 22 in brackets 2, paragraph C, it's also important to be read into the record.
Perhaps I'll, for the sake of clarity, read section 22(2) in completely again, well, not just this part of it. In accordance with section 179 of the Constitution, the National Director, A, must determine prosecution policy and issue policy directives as contemplated in section 21. B, may intervene in a prosecution process when policy directives are not complied with. And C, may review a decision to prosecute or not prosecute after consulting with the relevant director and after taking representations within the period specified by the National Director of the accused person, the complainant, and any other person or party whom the National Director considers to be relevant.
Now, under what circumstances, Advocate Batohi, would you, as the National Director of Public Prosecutions, review a decision to prosecute or not to prosecute? In practice, how would you go about it?
There is, I think it's section 20, I'm just trying to find the section that deals with the review, and I'd rather read that into the record. It specifically sets out the instances when a national director may review a decision. If I could be directed to that, I think is it 24, is it 20?
Section 22(2)(c).
22, which I have read into the record, Chairperson.
Yes, you've already read it into the record, Advocate Batohi. You've already read it into the record.
Yes, that's correct. If Council can please repeat the question.
My inquiry is, in practice, as a National Director of Public Prosecutions in the Republic, how would you go about reviewing a decision to prosecute or not to prosecute?
A national director can decide to review a matter if it is a representation is made by any party to the national director to review a matter, and the NDPP can review a matter if there's contravention of prosecution policy. And those are that's generally the way the trigger, the powers of a national director in respect of review are triggered.
I'd like to take you to paragraph 13 of your affidavit, which deals with section 22, where you deal with section 22 of the NPA Act. You are referring in this paragraph to additional powers which are contained in subsection 3, subsections 3 and 4 of section 22. Would we take the liberty, therefore, for purposes of completeness, to read into the record section 22, subsection 3 of the NPA Act, and then thereafter deal with those additional powers as you deal with them in practice, as they pertain to your duties?
So section...
Counsel, may I please interpose? It will be helpful if you refer to a paragraph in the affidavit itself, so that we can all zoom into that paragraph, and it will also assist the witness. I know for this purpose you're referring to paragraph 13.
Indeed,
It will
Madam.
be helpful if you can do that step by step, so that we can all follow where you are on the affidavit. Did you do that?
I take that. I was still on paragraph 13.
Did you refer us to her to paragraph 13?
13, 1-3.
1.3.
Yes,
Yes,
and where she deals with
Additional powers.
additional powers, and I asked her to read, for purposes of completeness and clarity of mind,
Yes.
subsection 3 of section 22.
So it is my mistake. I thought that you simply referred to the words without saying that is in paragraph 13.
Paragraph 13, yes, I did that, Madam. Thanks.
If
you-
I may.
May you proceed, therefore, to read into the record, Advocate Batohi, subsection 3 of section 22. You don't necessarily have to start with the main section 20, but subsection 3. And thereafter, you also read subsection 4 of the same section. Please do so.
Subsection 3 of section 22 reads as follows: where the national director or a deputy national director authorized thereto in writing by the national director deems it in the interests of the administration of justice that an offense committed as a whole or partially within the area of jurisdiction of one director be investigated and tried within the area of jurisdiction of another director, he or she may, subject to the provisions of Section 111 of the Criminal Procedure Act 51 of 1977, in writing, direct that the investigation and criminal proceedings in respect of such offense be conducted and commenced within the area of jurisdiction of such other director. And did you say 4 as well, Counsel?
I said 4 as well, and you'll then revert back to 3 after you shall have read 4 into the record.
Subparagraph 4, subsection 4 of Section 22 reads as follows: in addition to any other powers, duties, and functions conferred or imposed on or assigned to the National Director by Section 179 or any other provision of the Constitution, this Act or any other law, the National Director is the head of the prosecuting authority, A, with a view to exercising his or her powers in terms of subsection 2, may, sub 1, conduct any investigation he or she may deem necessary in respect of a prosecution or prosecution process or directives, directions, or guidelines given or issued by a director in terms of this Act, or a case or matter relating to such a prosecution or prosecution process or directives, directions, or guidelines. B, direct the submission of and receive reports or interim reports from a director in respect of a case, a matter, a prosecution, or prosecution process, or directions or guidelines given or issued by a director in terms of this Act. And sub 3, advise the Minister on all matters relating to the administration of criminal justice. B, shall maintain close liaison with the Deputy National Directors and Directors, the prosecutors, the legal profession, and legal institutions in order to foster common policies and practices and to promote cooperation in relation to the handling of complaints in respect of the prosecuting authority. C, may consider such recommendations, suggestions, and requests concerning the prosecuting authority as he or she may receive from any source. D, shall assist the directors and prosecutors in achieving the effective and fair administration of criminal justice. E, shall assist the Deputy National Directors, Directors, and prosecutors in representing their professional interests. F, shall bring the United Nations guidelines on the role of prosecutors to the attention of the directors and prosecutors and promote their respect for and compliance with the above-mentioned principles within the framework of national legislation. G, shall prepare a comprehensive report in respect of the operations of the prosecuting authority, which shall include reporting on sub 1, the activities of the National Director, Deputy National Directors, Directors, and the prosecuting authority as a whole.
Allow me to interpose. You may exclude 2, 3, 5, and Romans 6. No, include Romans 6. I beg your pardon. Exclude 3.
So this report shall include reporting on the personnel position of the prosecuting authority. 4 would be, excluding 3, 4 would be any recommendations or suggestions in respect of the prosecuting authority. 5 is information relating to training programs for prosecutor, and 6, any other information which the National Director deems necessary. H, may have administrative work connected with the exercise of his or her powers, the performance of his or her functions, or the carrying out of his or her duties carried out by persons referred to in Section 37 of this Act. And I, may make recommendations to the Minister with regard to the prosecuting authority or administration of justice as a whole.
Omit 5. Go to 6. Omit subsection 5.
Subsection 6A, the National Director, in consultation with the Minister and after consultation with the Deputy National Directors and Directors, shall frame a code of conduct which shall be complied with by members of the prosecuting authority. B, the code of conduct may from time to time be amended and must be published in the Gazette for general information. 7, Should I proceed with 7, sub 7?
For the moment, you may leave 7. Go to
8.
8.
The National Director or a person designated by him or her in writing may, if no other member, if no other member of the prosecuting authority is available, authorized in writing any suitable person to act as a prosecutor for the purpose of postponing any criminal case or cases, B, authorize any competent person in the employ of the public service or local authority to conduct prosecutions subject to, I don't think this applies in this matter, but for the sake of completeness, I continue, subject to the control and directions of the National Director or a person designated by him or her in respect of such statutory offences, including municipal laws, as the National Director, in consultation with the Minister, may determine.
9.
9, the National Director, subparagraph 9, the National Director or any Deputy National Director designated by the National Director shall have the power to institute and conduct a prosecution in any court in the Republic in person.
For the moment, that will be all. Let's go back to section 22 in brackets 2, subparagraph C. And I earlier indicated to you that I would like you to explain under what circumstances, as a National Director of Public Prosecutions, would you review a decision to prosecute or not to prosecute? In broad general terms, we may revisit this topic later on in your testimony, but for the moment, would you explain in broad outline how you go about reviewing?
So once a matter is referred to the National Director for a review, there is a section in the NPA, a business unit in the NPA called the National Prosecution Service, which is headed up by a Deputy National Director of Public Prosecutions. This is not in my affidavit, anyway in my affidavit. This particular unit is responsible for all general prosecutions across the country. So the directors of public prosecutions would report to the National Director, but through the Deputy National Director, who is the head of the National Prosecution Service. And the DNDPP, as I will refer to the Deputy National Director as of the NPS, has delegated power to deal with representations in terms of the Act, but all representations and reviews are processed through this office, and they would obtain statements from interested persons, affected persons, the DPP concerned, and they would then submit the file to the National Director, and then the NDPP will then consider the matter. That is basically how the process of reviews are dealt with in the office. If necessary, in some instances, well, I would, as the National Director, I have appointed panels to assist in the review process, whereby the case will be presented to a panel, and that would happen on occasion if the matter is particularly complex.
If I may, Counsel, and that will be for the purpose of deciding whether to prosecute or not to prosecute.
Generally, it is a representation that we receive mainly from accused persons, mainly. So once we get the accused would be requesting the National Director to review and to withdraw charges. So the process would be to review it and to establish whether there is sufficient evidence to sustain a prosecution or not. So if the National Director finds that perhaps there is merit in the representation, then it's possible that a decision could be made to withdraw the charges. On the other hand, if the National Director finds that there's sufficient evidence to sustain a prosecution, then the decision would be that the prosecution must continue.
I see the provision 22 sub 2C speaks of to prosecute or not to prosecute. And you speak of a request to withdraw the charges. If you can assist me to understand these concepts within the framework of prosecution itself. I'm not sure whether withdrawal could be synonymous to non-prosecution.
Thank you, Chairperson. I'll deal with that. They are different. Non-prosecution is what we use a term called decline to prosecute. And that would be in instances where a docket is handed to a prosecutor for a decision, and if the prosecutor finds that there is insufficient evidence to meet the standard, which is reasonable prospects of a successful prosecution, then the prosecutor will decline to prosecute. And in that instance, the matter is not even enrolled in court. So that's decline to prosecute. But if a matter is enrolled in court, and then the prosecutor decides not to proceed with the matter before plea, and I emphasize before plea is taken, then the charges can be withdrawn. If for whatever reason, there may be representations, that is a withdrawal of a charge, but it has already been enrolled. If the prosecution the trial has started, and the accused person has pleaded already, then that requires a stopping of the prosecution, and that is very rare that that happens. And my understanding is it requires the authority of a DPP to actually stop a prosecution. So a prosecutor in the courts cannot stop a prosecution. They can certainly withdraw matters, but they cannot stop a prosecution. They require the authorization of the DPP. So those are the three phases when a prosecution might not continue for various reasons.
Also, just to clear my mind, in the case of a withdrawal before pleading, when the matter is withdrawn, in that instance, does it mean that it can be reinstated?
That is correct, Chair. It can be reinstated in those circumstances.
At the practical level, withdrawals will happen, I suppose, where there could be insufficiency of evidence at that stage, before the pleading stage. Am I right?
That's possible, Chairperson.
It could also happen in instances where a prosecutor seeks to obtain certain information. Say, for instance, like in this case, and if I'm wrong, do tell me, where the prosecutor decide, I'd like to refer the matter first for inquest so that I can have a holistic picture regarding this aspect, maybe of murder.
Yes, absolutely, Chairperson. I want to hasten to add that later on I will explain why that decision was perhaps not the best in the circumstances, but that will be dealt with in a lot of detail. But to answer your question, yes, that is possible.
It's one of those maybe numerous instances where there could be a withdrawal before the pleading stage,
That is correct, Chairperson.
which then means, for instance, in the case where the evidence was considered to be insufficient and later becomes sufficient, a prosecutor could then reinstate the matter. The prosecution.
Yes,
or
if the evidence is indeed considered to be insufficient, can withdraw and then at a later stage reinstate. Correct.
Thank you very much, Counsel. I'm sorry to interpose.
You are at liberty, Madam Chair.
Criminal prosecution is complex.
It's very complex. You are at liberty to interpose at any moment that you would like to clarify your mind. I'm amenable to that situation.
Yeah,
Thank you, Madam Chair.
Yeah, I think at the time when you were asked questions, you were at a point when you were dealing with the issues of review by the national prosecutor. And through delegations, this responsibility, as you have stated, is granted to the deputy national directors under that particular business unit. And you have also stated that over and above these business units, you also have the panels that are established for the purpose of dealing with reviews, especially in cases that are regarded as complex. Now, what is the position? I'd like to draw a parallel between the business unit that is headed by the deputies as against the panel that is brought in whenever, I don't know whether it's whenever a case is seen as being complex.
Yes, certainly I can explain that.
Yes, please do explain that.
Let me explain that the panels, if a matter is, I'm reviewing a matter, and as I said, it's particularly complex or sometimes very high profile, so the reputational risk to the NPA is high, and we need to make sure we get the decisions right. As the national director, I would request that a panel be set up. The panel is actually an internal panel that is made up of very experienced prosecutors from wherever in the country that would sit as a panel and then consider the matter and make a recommendation to me in some circumstances. So that's essentially how, well, they would almost always make a recommendation. It would be very rare that they wouldn't, because that's the whole purpose of a panel. But it is an internal mechanism that I've put in place to assist in dealing with some of the more complex or high-profile matters.
Right, a follow-up to that. A decision whether to bring in the panels as against the business unit, does it lie solely with yourself? Is it within your discretion as the head of the institution, or what is the position?
If I am reviewing, as a national director, I am reviewing it, then of course I will request a panel to deal with it.
When this panel is constituted, is it constituted also with the participation of the deputy directors of public prosecutions, or is it, when you constitute it, you don't even consider taking members that are, one can say, for lack of a better word, automatically qualify by virtue of being in this business unit? Would you also rope them into this panel that you constitute, or you have a choice whether to do it or not? And if you have a choice, what are you inclined to do? Do you normally also rope them in, or does it become something that is dealt with exclusively by this panel that you would have constituted, on your understanding that the matter is either high profile or it's complex?
We don't have a hard and fast rule about that. Of course, I will consult with my deputy and we will talk about it. Sometimes the deputies will sit in and sometimes not. So it depends. There's no hard and fast rule about it.
In your view, do you think that, I'm trying to understand as to what informs this decision of involving the panel. In your view, would you do this because you suspect that there may be some deficit of competency in the business unit that would then bring about a need to constitute the panel? And if your answer is no, then maybe just bring us in to understand as to what thinking brings about the establishment of the panel.
Sure. To answer your question, it's definitely not because of a deficit of competency at all. It is merely because, as I said, when a matter is particularly complex or high profile, it's better to have more experience and heads considering a matter than one. So that is the reason for having a panel of experienced prosecutors. It might be a very highly complex corruption, money laundering matter, and then I'll look for prosecutors in the NPA, together with my deputy, of course. Generally, they set up the panels with prosecutors that have particularly vast experience in these types of cases, and then get them on the panel so that they can consider the evidence and advise the national director. So that is the thinking beyond it, because it's also, with very high profile and complex matters, you want to minimize the risk of getting things wrong. So it's trying to get more heads together to consider a matter. And of course, ultimately, it is the national director's decision. So the national director has got to consider it and take a decision on the basis of the evidence. So that is basically the reason for having this panel. And I suppose I should say that it's a kind of practice that one of the good practices that I picked up from my time at the International Criminal Court, where whenever a case was involved and was going to be enrolled or various, there would be a review committee set up where the experienced prosecutors in the office would sit together, team would present, just to consider the matter and to assist with gaps and things like that. So it was on that kind of thinking that I thought that would be a good idea to bring forward, and so we've tried to sort of institutionalize that kind of practice. So we also, and we've done it, I've spoke to you about it in the context of a review, but some DPPs also do it in their divisions where they have very complicated matters. They would hold a kind of review team where the team would present to the experienced prosecutors, and where these prosecutors would guide them and say to them, you have gaps here, let's look at this angle. And so that as a team, as a collective, you really make sure that you have a solid case when the matter does go to court. But that's at a different level. So we're trying to institutionalize that practice where we really harness the good experience and make sure we get the decisions right.
Just this last one. Over the period that you have served in the seat that you are currently occupying, has it ever happened that the personnel in the business unit would, once given a case to consider for review, they would then approach you to say that we think we need assistance. We cannot do it on our own and finalize, and we recommend that you beef us up as the business unit. Has it ever happened over the period?
Yes, we have certainly strengthened teams in the NPA.
Yeah, but did you hear the question? The question is, have you ever had a time where you would be approached by the business unit to say, we think we need to be supplemented or augmented, so we don't feel that on our own only we can carry this task, because we have identified that this task is quite complex, or it would be in the best interest of justice that you beef us up, because the case that you have referred us to or that we are dealing with is a high-profile case. Has that happened? Basically on the request coming from the unit. Thank you.
Thank you. That's understood. Yes, it has happened when that has been the case, and we will consider, because one of the functions of a national director, one of this is to support the DPPs in the divisions, and there have been instances when that happens. We look at how we can support the teams. We have also resorted to the appointment of outside counsel in terms of Section 38 of the NPA Act to assist in a number of complex cases where they've come forward and said for various reasons the DPPs request that they require assistance, and then we have made lots of Section 38 appointments, as we call them. So that has happened, and we do, of course, want to try to support the teams as much as possible. So we do try to give them the support that they need.
Thank you.
Thank you, Madam Chair.
Proceed, sir.
Thank you, Madam Chair. Advocate Batohi, a few moments ago, Madam Chair was asking you about a withdrawal, which you dealt with, because she wanted to clarify her mind. She wanted to understand under what circumstances the prosecutor can withdraw. And you explained it. But there is also what is called provisional withdrawal. Can you explain that? As against perhaps a permanent withdrawal, if I may use that pun. It may not be used in prosecutorial circles.
Yeah, sure. Look, the practical impact of a withdrawal or a provisional withdrawal is zero. There's no practical impact, because any withdrawal can be reinstated at a later stage. And so in instances where a prosecutor understands that there is a likelihood that I'm going to get more evidence, and you clear at that point that there's some investigations outstanding, and then you know that there's a good chance you're going to reinstate it, you would actually say it's a provisional withdrawal. But in instances even where a prosecutor withdraws a case, the point I'm trying to make is that once a matter is withdrawn, it can always be reinstated for any reason. Sometimes you may withdraw a case because the witnesses are not at court, and the matter has proceeded for a while, and the prosecutor decides, I'm not going to get another adjournment, realizes, so you withdraw a charge. And then you try to get the witnesses and whatever happens, and then you reinstate it at a later stage. So that's the point I want to make, is that there's no practical implications that are different, but you will provisionally withdraw in circumstances where you feel, and I'm repeating myself, that there's a strong possibility that you will reinstate if certain investigations or other requirements are met, for want of a better word.
Let's proceed and deal with paragraphs 15 for now, and 16, perhaps a portion of 17. In paragraph 15 of your affidavit, you deal with section 22.6, which you have already read into the record. Where you are enjoined to draft a code of conduct, to frame a code of conduct, and policy. There is a code of conduct in existence, not so.
That is correct.
It is currently applicable to all the prosecutors and binding on them,
That is correct.
as well as a code of conduct.
Yes, that's correct. As you'll notice in terms of, in paragraph 15, in terms of section 22(6) of the Act, NPA Act, the NDPP is required to frame a code of conduct. And this was done, it was drafted and gazetted in 2010. In fact, I was fortunate to be part of a team before that, before I left. Well, in the early development of the code of conduct, I was, of course, out of the country by 2010. According to the preamble of the Code of Conduct, due regard was had to the United Nations guidelines on the role of prosecutors and the standards of professional responsibility and statement of the essential duties and rights of prosecutors, which I mentioned earlier on as well. And yeah, so there is a code of conduct in existence, and it's binding on all prosecutors, including the National Director.
You also mention in these paragraphs the UN guidelines, United Nations guidelines on the role of prosecutors, which the law, the NPA Act, obligates you to bring to the attention of all prosecutors.
That is correct.
Was that done? And
It has been done in the context of the Code of Conduct. It's been incorporated into that.
maybe I should rephrase. Let me take you to F, 22, section 22, 4F. Are you there?
Yes, I see that.
It says, shall bring. The National Director, as the head of the prosecuting authority, shall bring the United Nations guidelines on the role of prosecutors to the attention of the directors and prosecutors.
I see that.
Yeah,
and that has been incorporated into the Code of Conduct, which has been brought to the attention of all prosecutors, and they are bound to comply with it. So in that way, this has been complied with as it's incorporated into the Code of Conduct.
The Code of Conduct, as you set out in paragraph 15, is in the bundle policies and directives.
That is correct.
It also contains the prosecutorial policies, not so. It's a code of conduct.
Sorry, I don't understand that.
I'm saying in the bundle policies and directives, it contains the code of conduct as well as the prosecutorial policies, not so. Prosecution policies.
I understand it does.
Let us then proceed to paragraph 27.
Counsel, if I may ask, before we proceed there, if I could just emphasize something from paragraph 15
Well and
on the Code of Conduct before we move off that.
well and good.
It's on page 8.
On page 8,
About 5 lines down. The Code of Conduct emphasizes the professional conduct, independence, impartiality, and objectivity required of prosecutors in exercising their powers and carrying out their duties and functions. It emphasizes the role of prosecutors in the administration of justice and also the role of prosecutors in ensuring the fairness and effectiveness of the prosecution process. And then it goes on to deal with other aspects of cooperation with various partners So I just wanted to highlight that aspect. Yes, thank you. You were saying, Council?
Yeah, it also mentions independence, which we will deal with later. The
Yes, that's
independence
correct.
of a prosecutor.
Absolutely, and that's critical.
Council, if I may, the policies and directions that you refer to that are mentioned in paragraphs 15, 16, and 17 are contained in a bundle, an index to folder marked policies and directives. Shouldn't we mark these bundles?
I beg your pardon, my lady.
Shouldn't we mark the bundles? We have bundles that you refer to us in your index. Now, at one stage, somebody is going to have to look for those documents. And these documents, the bundles that you see behind us, are not marked. I'm asking you that whether it is not appropriate at this stage, as you refer to them, to mark them appropriately.
In other words, if I understand, Madam Chair, clearly, to be
As-
marked and also properly paginated.
I don't know about the pagination. I have my bundles. But this bundle doesn't have a name. It has a name, policies, and directives. Now, if anybody reads the record, is going to look for this bundle. Shouldn't we mark this bundle, perhaps refer to it as Bundle A?
Give it a name, a tag. I agree.
It doesn't matter what you call it, but what do you
Yes.
call it? You may suggest to us, what do you refer this bundle of policies and directions?
May I confer with my junior? It's easier. She draws my attention to the fact that it's marked. Actually, it's given a name. It's
Just
named
tell me what the name is.
PD.
I beg your pardon?
PD. Whatever PD stands for.
PD.
Yes, PD.
Policies and directives.
Policies and directives.
So we must mark it PD.
It's all,
They-
yes.
PD.
Chair, at the end of, to help, if I may, page 8, and I know junior counsel might know better than I do, but at the end of paragraph 15, it says, marked, forms part of the record under bundles, policies, and PD 00011 to PD 16. And these are these particular ones. I'm not sure if that helps, Chairperson.
It does help, but the actual document, you see what I have, and these bundles and bundles behind us are not marked. I'm saying, shouldn't we then mark them according to the affidavit? You understand what I'm saying, Council? The affidavit refers to this name.
SPD.
Yes, it's PD 0001 to PD 0016. I'm now suggesting to you whether we should not mark them accordingly. And I think as the evidence leader, you should then direct us or suggest to us that let's mark them accordingly, because we're going to mark other bundles. So this one of policies and directives of the PD 0011 to PD 0016. Which one, how do you mark this one? Should we mark it PD 001, policy directions?
I must give it a thought. I must give it a thought before I say it must be marked.
Please confer with your junior. You can switch off your mic so long.